Recording. Tuesday, September 1st, 9:25 a.m. We are about to establish contact with the 13th Judicial Court in the District Court of Valencia County at the state of New Mexico. We're going to challenge the fact that counsel and judge have been disbarred by the New Mexico State Bar Association effective on August 30th, by the end of business day of August 30th of the year 2020. We have served the court with the criminal complaint filed on April 6th of 2020. And for the Honorable J. Jesus-Arriaga Abonce and the Honorable Adelina Arriaga Pedrosa are ready to challenge in regard to any jurisdiction this court may have, since it is the inferior court, is a court of a limited jurisdiction. So we will challenge their jurisdiction and their authority. Now we're going to pause here for a minute while I am dialing this number, cell phone number. Area code 505 865 2400.
Hello, you have reached the 13th Judicial District Court in Valencia County in Las Lonas, New Mexico. Please listen carefully as our options have changed. Office hours are from 8 a.m. to 5 p.m. Monday, Tuesday, Thursday, and Friday. Wednesday, 8:30 a.m. to 5 p.m. We are closed daily for lunch from 12 to 1 p.m. If you know the extension of the person you are trying to reach, you may dial it at any time. Otherwise, choose from the following.
Extension 2400.
Jaramillo, please leave your message after the tone. When done, hang up or press the pound key. Thank you. Press 1 to accept this recording. Press 2 to listen to it. Press 3 to re-record your message. Press 4.
No, we need to redial again. It's area code 5, 05 865 2400.
In Valencia County and Las Lonas, New Mexico. Please listen carefully as our options have changed.
Extension 2400. We're going to have to redial 505 865 2400 and then send.
District Court in Valencia County and Las Lonas, New Mexico. Please listen carefully as our options have changed.
Extension
Office hours are from
027. enter code
Please enter your password
12
followed.
35 pound.
Thank you. There are currently 3 other participants in the conference.
Good morning, this is Judge Mercer, who's joined the line.
This is Catherine Sanchez. I am substituting in for this hearing for Elizabeth Friedestein, Bank of Oklahoma.
Objection, Your Honor. This counsel has no authority, no first-hand information. This is Jesus-Arriaga, Abonce, and I am objecting. If you don't let me talk, I will charge you with violation of the First Amendment. This plain and simple, okay?
Charge me with that
Yeah.
in a few
You
minutes,
are-
but
you
we're
are-
not on the line yet.
You
We're
are in
not
a recorded
started yet,
line.
So you need to just identify who you are, so I know who's on the line for the hearing. Who are
The
you?
time now is 9:31. This court is now on section. For the Honorable J. Jesus-Arriaga Abonce, Special Master in Common Law, Federal-Postal-Judge Sui Juris, and one of the people, case number D-1314-CV-201901401.
Prohibit you from being on the line. You need to stop talking until we start the hearing. This is my courtroom, thank you.
This is not your courtroom. It is my venue. I understand this is your courtroom, but you have no authority. You're in
I
violation.
have authority to decide how we're going to conduct this hearing. This is my courtroom, so you will wait until you are asked to speak. Thank you.
I object. You have no authority. This is not your courtroom. You are not the injured party. The judge is independent of the tribunal. And under common law, the petitioner is the judge. And I ask you to refrain. You've been disbarred as August 30th by the New Mexico State Bar Association. The application for your disbarment has not been rejected. Please be advised.
On the record,
Please
you're
be
wasting
advised.
your breath.
I
You
am.
might want to wait until we get started, and then you can make your objections for the record. We're not started.
I have my own record. I am in the Superior Court of Law, and I am entitled to save my own record. You have no authority to perform, and this will constitute forensic evidence of violation of 6 CFR Section 37.3. If you continue in this path, this video recording is going to be saved for the forensic evidence in regard of your violation of 6 CFR 37.3, Title 18, Section 241 and 242, violation of rights under color of law, conspiracy, violation of Title 18, Section 641. I am not a sir.
If you do not stop talking until I have gone on the record and give you a permission to speak, you will not be permitted to participate in the hearing. It'll be reset, and you will not be part of that hearing. So you can either wait until we call the case and wait until you are acknowledged to give your opportunity to speak, or you will be prohibited from participating. Those are your choices.
Under what code can you prohibit somebody?
This is Judge Mercer, who has joined the line.
Oh, good morning. This is Diego Honda appearing for Bank of America. I unfortunately was trying to call in to the conference line, but was
Objection. This counsel has no authority and has no license to practice on the state of New Mexico. This counsel.
Yeah.
Thank you. I just wanted to make sure that I could understand who was on the line. Thank you.
Of course.
All right, we're going to call the case now in the matter of Bank of Albuquerque N.A. versus Jesus-Arriaga Ponce et al. Case number D-1314-CV-201901401. Each party will need to state their name for the record, please, at this time.
There is a mistake. The case number is D-1314-CV-201901401.
All right, again, as I've asked, if the parties can please make their appearance for the record and stating who you represent.
Good morning. Good morning.
Go ahead, Jay. Sorry. My name is Catherine Sanchez, attorney here at Weinstein Riley for the plaintiff, Bank of Albuquerque. I am subbing in for Elizabeth Friedenstein.
Thank you.
Good morning. This is Tia Rotunda appearing for Cross Plaintiff Newrez LLC, doing business as Shell Plaintiff Mortgage Servicing.
Thank you.
Good morning. This is Andrea Hicks for Deutsche Bank National Trust Company as successor trustee to Bankers Trust of California.
All right, Mr. Arriaga, do you wish to make your appearance for the record, please?
Objection for the Honorable J. Jesus-Arriaga is not a Mr. For the Honorable J. Jesus-Arriaga Abonce, Special Master in Common Law, for the Honorable Adelina Arriaga Pedrosa.
Thank you. All right. We are here on motions to strike that have been filed by the plaintiffs in this matter. We have one motion to strike filed on June 19th, 2020.
Objection. Objection.
We also
Objection.
have another motion to strike that's been filed on August 17th, 2020. Making similar requests, and so I know this was Ms. Friedenstein's original motion, so Ms. Sanchez, if you wish to proceed on your motion.
Yes, Your Honor.
Objection, 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 objection. This counsel has no first-hand knowledge, Tinsi versus Pagliaro, and therefore she cannot testify.
You will be given your opportunity to speak. But
I am speaking.
Speak at this time, and if you continue to speak over people, you will be excluded from the hearing. So I'm going to ask at this time that you wait your turn. Everyone will have their turn to speak. This
I
is
have
not
the-
your turn.
I have the right to object, Your Honor.
For the record, when it is your turn. Ms. Sanchez, you may proceed.
Defendant filed 3 papers with the court. The first was dismissed with prejudice and filed December 10th, 2019. The second was judgment of default, filed December 27th. The third was criminal complaint and was filed June 3rd. That same complaint was filed again in August 31st. Your Honor, defendants' filings are redundant, immaterial, legally insufficient, and obviously scandalous. The arguments and threats expounded at length in defendant's filings are characteristic of his theory of sovereign citizen movements. The filing should not only be stricken, but justify a court prohibiting the defendant from proceeding pro se.
And I object.
Due to
Mr. Arriaga, as I've said, you'll have your chance to speak. Ms. Sanchez's turn is now. Ms. Sanchez, you may proceed.
Yes, and Your Honor, due to the defendant's assertion of this sovereign citizen theory and multiple filings, make these frivolous arguments. Plaintiff praised the court entered an order banning or barring defendants from further filings without leave of court or unless represented by counsel, as the 10th Circuit found in Norton, awarding plaintiff's attorney's fees for the motion and any other further motion. The plaintiff is respectfully requesting that the court enter an order striking defendant Arriaga's miscellaneous entries on December 10th, December 27th, June 3rd, and the same criminal complaint on August 31st, 2020. Thank you.
Ms. Hicks, do you wish to weigh in on this motion?
I have to object, Your Honor.
Thank you.
All right. Ms. Rotunda, do you wish to weigh in on this motion?
No, I have no objection to plaintiff's motion.
All right. Mr. Arriaga, you may respond to the motion.
In response to the motion for the Honorable J. Jesus-Arriaga Abonce reserves the right under UCC 1-103.6, which says, The code is complementary to the common law, which remains in force except where displaced by the code. A statute should be construed in harmony with the common law unless there is a clear legislative intent to abrogate the common law. At the end paragraph of this UCC 1-103.6, which the Honorable has reserved its rights, and 1-308 of the UCC, and 1-109, it reads that the code cannot be read to preclude a common law procedure, a common law action. This is a common law action that was brought into federal court. There is an existing judgment, and the documents the counsel just mentioned have not been challenged at all, and therefore they have acquiesced. I have this copy in my hand, and we can read it. I'm going to read it for the record.
Mr. Arriaga, you don't need to read documents as part of the court record at this point. You can make your argument. You're
Your
not going to
Honor,
read documents.
I haven't finished making my argument, and I certainly will appreciate if I am allowed to speak. The document,
You may proceed.
it is stated on the default judgment that the opposing counsel, Elizabeth B. Freudenstein, has no authority, has no first-hand information, Tinsley versus Pagliaro, and she is incompetent to testify for a third party that do not exist. Further, I am going to say this for the record and on the record, the last section of UCC 1-103.6, which says that the code cannot be read to preclude a common law action. And therefore, she has no authority, she has no first-hand information. If she's going to speak, I want this counsel to be sworn in because I have a few questions for her. Mrs. Elizabeth B. Freudenstein, please state your name, your full given name for the record.
Mr. Arriaga, we're not taking testimony today, so you may proceed
I am
with your
entitled.
arguments, or I'll consider your arguments concluded and I'll make my ruling. That's your choice.
I have not finished with my arguments. I have another 2 hours of arguments, okay? The code recognizes, the code recognizes, the code,
Your objections and your arguments to the motion only.
okay?
And you will not be calling any witnesses. We are not here to take testimony. This was not noticed as an evidentiary hearing. You may make your arguments. You'll have a few more minutes to complete your arguments, and then the court will make its ruling. So you may either proceed with your arguments or the court will make its ruling.
I will proceed with my arguments. The code recognizes the common law. And if it did not recognize the common law, the government will have to admit that the United States is bankrupt and it is completely owned by the creditors, but it is not expedient to admit this, so the code was written so as to be abolish the common law entirely. Therefore, you have made a sufficient, timely, and explicit reservation of the rights. The Honorable J. Jesus-Arriaga Abonce has reserved its rights under the UCC 1-308, Old 1207, and this hearing may not proceed because if the court operates under the common law and honors the UCC, the court cannot, the inferior court cannot uphold one portion of the UCC and deny the other portion. I have a question for the Honorable Cindy M. Mercer. I have a question. Is this a judicial proceeding or is this a statutory proceeding? I don't understand the nature of.
Or I'm going to make my ruling. That's your choice.
I have a question for the Honorable Cindy M. Mercer to answer. For the Honorable J. Jesus-Arriaga, do not understand these charges. The name is not the name. They are not the correct parties at interest, as stated on case number 120-CV-0013113-JHR, filed in the United States Court, Albuquerque, New Mexico, on April 6, 2020. Now, if the court cannot honor the UCC, the court will be, Your Honor, I can sue you under the common law for violating my right under the Uniform Commercial Code. I have a remedy under the UCC to reserve my rights under the common law, and I have exercised that remedy. And now you must construe this statute in harmony with the common law. You must come forth with the damaged party. If there is no damaged party, you have no cause. I haven't finished with my arguments. However, if you insist or continue, I will have to read the last portion for the record, and in the record that in the last sentence of UCC 1-103.6, which states the code cannot be read to preclude a common law action. If I may, I haven't finished. I haven't finished, Your Honor. I haven't.
You only have to direct your arguments to the motion.
I haven't finished. I need to make a statement.
You will be given a couple more minutes to direct your arguments to the motion, and then we will make a ruling.
Your
May we
Honor.
proceed?
Your Honor, for the record and on the record, I preserve, for the Honorable J. Jesus-Arriaga, preserve the right not to be compelled to perform under any contract, commercial agreement, or bankruptcy that I did not enter knowingly, voluntarily, or intentionally. And furthermore, I do not and will not accept the liability of the compelled benefit of the unrevealed contract or commercial agreement of bankruptcy. I have requested a copy of the contract. Counsel has been unable to present the real contract signed by both real parties. Without a contract, this case may not proceed. And if there is a contract, I would like to see it before this case proceeds, so maybe I can question the integrity of the contract. And the parties listed on the contract is being specified in several occasions that is not the real parties at interest. On the rogatory that it was filed on this court, we moved forth and we said the following. We said that this court has no jurisdiction over this matter, and the addition of the use of a fictitious plaintiff makes this action a fiction and affords no power to this lower court for any action where no justiciable issue is presented to the lower court through pleadings. Ligon versus Williams, 264, 3 at 3rd 701.637, Northeast 63, 1st District of 94. As an instance, the order hereby is a sovereign secure party, not any witness, for the failure of this false fraud claim. Charge is with the violation order of this false fraud case. Charge indictment by the lack of authorization for the relief. Civil claim 12B6 with the non-compliance is with the issue of a bench warrant, and this document was filed in this case, and the opposing counsel was not even competent to challenge. It is unchallenged, and therefore they have acquiesced, and they have no legal reason to continue. If this is not challenged, I'm hereby questioning the jurisdiction of this agency. For the Honorable Elizabeth B. Freidstein has 4 other names pursuant the record of the documents filed in your office yesterday around 4:30 p.m. And if I can direct you to it, Everything is on the record. Now, take mandatory judicial notice of the law.
Your arguments are complete. You're starting to get into issues that do not relate to the motions that are before the court today.
Is your contempt ruling?
Mr. Arriaga's arguments with regard to the motion to strike today.
Objection, objection, objection. For the Honorable
Your
J.
objection
Jesus is not a
noted for the
Mr.
record, Mr. Arriaga, you need to stop talking. You had your opportunity to respond to the motion. Ms. Sanchez?
I haven't finished.
To respond to the arguments of Mr. Arriaga.
Your Honor, it's very difficult to recognize any of the arguments because, as I indicated before, they have no basis or merit. They're frivolous, and I'm not sure how to address them
All right.
at this point.
Please let the record indicate that counsel is not sure how to address this. Therefore, she is incompetent to testify. She has no license to practice.
Mr. Arriaga, you have had your chance to speak. You
The
need to
code-
stop talking.
the
I
code
gave you your
recognizes-
opportunity.
The code recognizes the common law, and if not
Mr.
recognize the
Arriaga,
common law,
You need to stop talking.
I'm not Mr. Please don't call me Mr.
The
MR.
court is going to rule as follows. This matter has not been dismissed with prejudice. The court is going to strike the document filed on December 10th, 2019.
Objection, objection. You cannot do that. You have no authority. You have been disbarred.
Filed on December 27th, 2019. This court has not issued a default judgment. That document will be stricken from the record.
And I will charge you criminally.
Filed on June 3rd, 2019. The court finds that the filings within that document contain references to cases that have nothing to do with this court or this matter before the court. It contains documents that are irrelevant to the responsive type of pleading that the court expects and that the rules require of civil procedure, and so the court's going to strike the pages listed under June 3rd, 2020 filing. And the court is going to strike the documents filed on August 31st, 2020, as they do not indicate what they are responding to. It does reference a criminal complaint. This is not a criminal action. And so the court is going to strike those documents from the court file, as this is not a criminal proceeding, it is a civil proceeding. The court is going to direct that any future filings, if they are filed pro se by Mr. Arriaga Ponce, that they will require court approval before they will be submitted and filed in the court record for the court to determine that they are consistent with the rules of civil procedure with regard to responding to a particular motion or cause of action before the court. The court is going to hold in abeyance the attorney's fees that have been requested by the party filing this motion, Ms. Regenstein's office, to not impose at this time, but if Mr. Arriaga does not comply with the order of the court, then the court will reconsider attorney's fees being assessed at a later date. The court will give Mr. Arriaga Ponce an opportunity to choose between hiring counsel who will be permitted to file proper pleadings with the court, or if he chooses to proceed pro se, it will require that the court approve any filings before they are placed in the court file. They will have to be filed consistent, as I said, with the rules of civil procedure. They will have to be titled appropriately as to what motion or complaint that they are referencing or responding to before they will be permitted to be filed. Ms. Sanchez, I will ask that your office prepare the order of the court from today's hearing. And the court will review the same and will enter it if it is consistent with the order of today's court. So you can send a copy to Mr. Arriaga Ponce and submit the order to the court directly for approval and signature. All right.
I put this court on notice that I am appealing the judicial determination. Of course, to the higher court will uphold the code on appeal. The judge knows that this is once again half boxed into a corner. The judge has no authority to proceed. Oh, did they hang up? Hello? Well, I reserve my rights under the 1-308. They cannot proceed. But she's ruling against it. Okay, well, then I'm going to challenge that. Well, for the record, I put this court on notice that I am appealing your judicial determination. Of course, the higher court will uphold the code on appeal. Let me see if I understand this, Your Honor. Has this court made a judicial determination that the sanction, that the section 1-308, 1-207, and 1-03.6 of the Uniform Commercial Code, which is the system of law that you are operating under, are not valid law before this court? Now, for the record, for the Honorable J. Jesus-Arriaga Abonce has reserved its rights under the Universal Commercial Code 1-308, 103.6 as is contained in the record, and 1-109. Let the record indicate that I've been cut off, that this conversation is still on, and that I am not allowed to continue as I explained. In section 1-103.6 speaks that the code cannot be read to preclude a common law action. And it was mentioned on the record also that this court has no authority, no jurisdiction. The jurisdiction is being challenged, and it will have to be proven. Jurisdiction cannot be assumed, and the documents of the Superior Court of Record cannot be dismissed by the Inferior Court of Record, which has no jurisdiction over the parties. And this case was dismissed on June 6 of 2020 in the United States Court for the United States District Court of Albuquerque, New Mexico, for the District of New Mexico. It is being decided by 3 federal judges that this case did not contain the real parties at interest, and therefore this case is dismissed or discharged with prejudice. The Code Section 18 U.S.C. 401 offense description, power of court. A court of the United States shall have the power to punish or by imprisonment or both at its discretion such contempt of the authority and none other as misbehavior of any person in its presence and so near thereto as to obstruct the administration of justice. Misbehavior of any of its officers in their official transactions, disobedience, or resistance to its lawful rate of process under rule, decree, or command. This criminal complaint is based on these facts. The individuals using the false identity 1 Cindy M. Mercer, 1 Elizabeth B. Friedenstein, the third-party representative for the fictitious entity Bank of Albuquerque, N.A., claim to be prosecuting this matter for a plaintiff having no legal standing in using an authorized process in a court of an improper venue, depriving the Honorable J. Jesus-Arriaga Abonce and the Honorable Adelina Arriaga Pedrosa of its protected rights under color of law in violation of Title 18 U.S. Code Section 242, which is denial of rights under color of law. Section 18 U.S.C. 241, a more extensive affidavit of facts was filed in the Inferior Court of the United States and the District Court of the District of New Mexico on February 7, 2020. For the Honorable, please take judicial notice of the law. For the Honorable J. Jesus-Arriaga Abonce Sui Juris, for the Honorable Arriaga Petrosa, Federal-Postal-Judge Sui Juris, and one of the people are peaceful inhabitants of New Mexico territory, truly believe the individuals listed on attachment 1 pursuant each of these case numbers using the false identification alleged prosecution for a plaintiff that has no legal standing in the state of New Mexico, is using an authorized process that violates Michigan Code 750.217C in proceeding whose defendants Jesus-Arriaga and Arriaga, legal fiction, Jane Doe and John Doe, are being coerced to accept as identification conducted in an improper venue, depriving us of our protected rights in violation of 18 U.S.C. deprivation of rights under color of law. A federal law that must be enforced at any courtroom flying a gold fringe flag, including the 13th Judicial District Court of Valencia County and the United States District Court for the District of New Mexico. We do not believe the attorneys and counselors of law are identified in the official roll of attorneys kept by the Supreme Court clerk in the style name of Cindy M. Mercer, Judge Juan Elizabeth B. Friedenstein, attorney for the fictitious plaintiff, Bank of Albuquerque, N.A., Carl W. Raystek, CEO and General Counsel of the 13th Judicial Court of Valencia County, New Mexico. These individuals use this false identification. It is insufficient evidence, and they are authorized to practice law in New Mexico territory, as I believe that in all legal matters, all involved must use their full legal name. The use of a middle initial violates 6 Code of Federal Rules, Section 37.3. Plaintiff Bank of Albuquerque has no legal standing to prosecute. The style of process being used is contrary to Michigan compiled law of MCL 600.1414. Style of process. The style of process from the courts shall be in the name of the people in the state of Michigan. Jesus-Arriaga and Arriaga, as found on the notice to appear that brings us to court, is not our full legal name and is not our identity. Is not us and is not our identification. County of Valencia is not a venue or political subdivision for the state of New Mexico and shares none of its sovereign powers. We do not believe any act, legislation, charter, articles, association of articles of incorporation, evidence of its lawful existence. We are not subject to this venue. Officers of the court are attempting to steal our identity and coerce us into being their bond servant under the fictitious name. They are doing so by simulating a legal process in violation of the state law, federal law, common law, and the law of God. They are using their office of trust for private gain. This affidavit is made on our personal acknowledge and is sworn as a witness. We can testify completely to the facts in this affidavit. Despite the actions of police and local courts, higher courts have ruled that American citizens have the right to travel without state permits, i.e. license plates, driver's license, registration, or car insurance. Common law right to travel. The right to travel is an unconditional personal right whose exercise may not be conditioned. Dunn versus Blumstein, 405 U.S. 33092 SCT 99531 LED second 2745 U.S. the constitutional law, and 10105 right of interstate and international travel. Travel is not a privileging, licensing, vehicle registration, or forced insurance. Let the record indicate that they have interrupted our closing arguments, and this is forensic evidence of violation of 8 U.S.C. due process violation, and this is forensic evidence on the record. The time now is 10:06 a.m. on September 1st, of the year 2020. This video is going to be published on YouTube as forensic evidence. You will be required to watch this video and challenge every statement that was made by the Honorable J. Jesus-Arriaga Abonce and for the Honorable Adelina Arriaga Pedrosa. If you shall continue in this path, this will be forensic evidence that you are practicing law without a license and you have no authority to rule in the superior court of record. The inferior court of record has no jurisdiction over the superior court of record's venue because its jurisdiction is precisely limited. Without jurisdiction, no ruling is valid. And how can they uphold one section of the Uniform Commercial Code and deny the other one? The record indicates that for the Honorable J. Jesus-Arriaga Abonce has reserved, and the Honorable Adelina Arriaga Pedrosa have reserved the right under the Uniform Commercial Code, Section 1-308, 1-103.6, and 1-09. And it is appealed to the Supreme Court for the analysis of the forensic evidence contained in this video and for its contempt. It's a contempt ruling and is hereby rejected. I will keep you informed and please stay tuned. I'm signing out. Thank you. And remember, they have no authority over the people unless they can bring you legislative, which is non-existence. And they have no authority. And this ruling was totally out of place, out of jurisdiction. Jurisdiction was challenged, it's arbitrary, and it's proven once more that they are practicing law without a license and without the proper oath that satisfies the 6th article of the Constitution. They are also, once in the end, Mercer is in violation of 6 CFR 37.3 as stated on the record, and 1 Elizabeth B. Friedenstein is in violation of 6 CFR 37.3, and they do not have any authority. They were requested their certificate of election, their certificate of authority on federal court. They failed to bring it down, and there is a judgment on federal court. And it cannot be challenged, as stated on the record. The decision of the Superior Court of Record cannot be challenged by any other jurisdiction. As we read it in the record, the use of a fictitious plaintiff makes this action a fiction. and affords no power to this lower court for any action where no justiciable issue is presented to the lower court through pleadings. Ligon versus Williams, 264 3 at 3rd 701 637 NE 633 1st District 1994. As it stands, the order herein hereby is as the sovereign secure party, notary, witness, postmaster, diplomats, J. Jesus-Arriaga Abonce, authorized agents for the fictitious entity or the capital name for the vacation of the order on this matter under Title 17 U.S.C. for the failure of this false fraud claim charge is with the vacation of this order with this false fraud case charge indictment by the lock of the authorization for the relief civil claim 12b6. And it was never challenged as contained in the record. In the refuse per cause per UCC 1-308, an affidavit of truth for the Honorable J. Jesus-Arriaga Abonce, Federal-Postal-Judge Sui Juris, and one of the people on the land of New Mexico territory being duly sworn, duty, post, and say that 1, I believe I have the right to travel in my personal car, automobile with guests as long as I am not engaged in commerce or being paid up on the public right of way, and I don't believe any evidence to the contrary exists to the Constitution of the Republic of New Mexico states the judicial power of this state is vested in the Supreme Court of Appeal and the Supreme Court of all which are courts of record. I believe a court of record is a judicial tribunal having attributes of exercising functions independently of the person of the magistrate, generally assigned to hold it. And proceeding according to the course of common law is acts and proceedings being controlled for a perpetual memorial in Jones versus Jones. I believe under the common law, unless an injured party, flesh and blood party, I have no liability to any party and no evidence to the contrary exists. I believe I have not injured any party for in this matter. I believe I have the right to claim sovereignty as evidenced by the Supreme Court case that states at the Revolution the sovereignty devolved on the people and no evidence to the contrary exists. Further, now I say not without prejudice, under my hand and sealed, the Honorable J. Jesus-Arriaga Abonce, Federal-Postal-Judge Sui Juris, performing in this Superior Court of Record. I will require the District Attorney's Office and or the Wonderland Superior Court to demonstrate the factual basis in law for any liability on my part to perform as the recipient of the noted tickets or the open cause. You failure to rebut my affidavit point by point with factual evidence dated and is not conditional acceptance point by point with the factual lawful evidence of liability within 3 calendar days from the time of this hearing, which is November 1st of the year 2020. Notice will be tacit agreement and silent acquiescence to the truth contained in said documents and result in the court of a district attorney abandoning the claim in any matter and result as an estoppel against the court, the district attorney from proceeding in any action against John Doe or Jane Doe in all capital letters for a fictitious entity. The Superior Court reserves all right to all affirmative defenses and retains all protective rights under UCC 1-308, 1-103.6, and 101-109. Further testimony will continue in a further video, but until this video is challenged fully, we will continue. Otherwise, this is forensic evidence of this malpractice that took place today by two criminals who are listed on the criminal complaint, and that they cannot practice or dismiss any cause or causes at the Superior Court of Record. September 1st of the year 2020. The time now is 10:16, and I am going to pause this or end this video for now. Thank you very much for watching, and I will be posting more videos.